Hello, my name is Anthony Duckett. I'm an associate attorney here at ChapmanAlbin. And if you're an investor, you might be wondering how the FINRA arbitration process works. So the first step is you give us a call. We have an initial consultation. You'll speak with an attorney. That attorney will listen to your story, take notes about your case, and we're probably going to need to see some documents. So we'll review the documents you send over, we'll listen to your story, we'll look into the broker who allegedly had this misconduct, and we'll see if he or she has a history of this type of conduct. And after we look into your case, we do our research, we'll decide whether or not to take it. If we decide to take your case, we'll be in communication with you and we'll file what's called a statement of claim. The statement of claim is like what a complaint would be for a lawsuit that was going to court. So we detail the allegations, we tell your story, and we put together a document that shows what we're alleging, what rules were violated, what laws were violated, and has a fact section that details all the things that happened to you and all the actions you took and all the actions the broker took. The next step is the other side, the brokerage firm that we're going after, and sometimes the broker himself will file what's called the answer. The answer is their response to the allegations in the statement of claim. So we lay out our arguments, they lay out their arguments, and they have 45 days after we file our statement of claim to file that answer. After they file the answer, then we select arbitrators. So we have a process. We have a network of attorneys that also practice in this area. We look at what they say about these arbitrators. We do our research into past awards that they've given, and we try to select the arbitrators we think would give us the best results. So after the arbitrators are selected, we have what's called an initial pre-hearing conference. The initial pre-hearing conference, we discuss deadlines. We go over, how many days there are to respond to motions, just technical stuff. And we lay out these deadlines, and then the discovery process begins. The discovery process will require documents from you. The other side will also produce documents. And there's no deposition process in FINRA arbitration, so the documents are very, very important. And the documents we get from the brokerage firm and the documents we get from you are the things that we base our case on. The documents we would request would be account statements, especially. We want to see what you were invested in, when you invested, communications. We want to see what you were saying to the broker, what the broker said to you about this investment. Did they tell you it was safe, no risk, things like that. We also want to see what the firm did to look into this investment, so their due diligence on their end. Anything they did to vet this investment before they sold it to the people who were customers of their firm. After we complete the discovery process, we usually try to negotiate a settlement, but sometimes you don't get to a settlement and you have to go to hearing. So the hearing date is set. You go to a hearing, it's usually in a conference room at a hotel or a high-rise somewhere, and you're sitting there. It can take anywhere from 2 weeks to 2 or 3 days, depending on the extent of the case, the amount lost, the number of witnesses. There are a lot of different factors. It is very similar to a court case in that there's an opening statement. There's two sides. Both sides call their witnesses, and those witnesses give their testimony on direct examination, and the other side has the opportunity to cross-examine those witnesses as well to get more evidence out of them that will be more favorable for their case. After all of the witnesses are called, there's a closing statement, and the arbitrators sit there for however long it is, and they listen to all this evidence. They take it in, and they have the opportunity to ask the witness questions as well while they're on the stand. So they take in all the evidence, they ask their questions during this hearing process, and after they hear all of this, there's closing statements. After closing statements are made, the arbitrators then have 30 days to decide the case. And you'll hear from them within 30 days. Something will be filed on the FINRA dispute resolution portal, and they'll give their answer on whether they find for $0, all of it, 100%, 50%. There could be various outcomes, but in that 30 days, you'll hear what the arbitrators decide. Throughout your case, you'll have an attorney by your side who's experienced in this area of law the entire time. We'll be communicating with you, we'll be helping you, we'll be holding your hand and guide you through this process, which is likely foreign to you. This process can take many months, but we'll be by your side, fighting for you every step of the way.